Presentation 1 by Marcus Rice. This presentation is going to look at Title VII and Title IX and answer three major questions. What is the difference between Title VII and Title IX? Does Title IX apply to same-sex harassment? How do these influence schools and students? First question we must answer. What is the difference between Title VII and Title IX? In answering this, we must first look at what Title VII actually is and what Title IX actually states. Title VII, under the Civil Rights Act of 1964. It shall be an unlawful employment practice for an employer to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. Title VII prohibits discrimination in employment on the basis of race, color, religion, sex, or national origin. In certain instances, differential treatment is allowed for religion, sex, or national origin if it is a bona fide occupational qualification. Sexual harassment is also prohibited under this law, as are all forms of harassment based on membership in a protected class. Title VII of the Civil Rights Act of 1964 is a federal law that prohibits employers from discriminating against employees. It generally applies to employers with 15 or more employees, including federal, state, and local governments. Title VII also applies to private and public colleges, universities, employment agencies, and labor organizations. So what does this mean? Employers cannot discriminate in any aspect of employment. It also prohibits retaliation against someone for asserting Title VII rights. Title IX. Title IX of the Education Amendments of 1972 protects people from discrimination based on sex and education programs or activities that receive federal financial assistance. Title IX states that no person in the U.S. shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Title IX prohibits sex discrimination in educational institutions that receive federal funding. This is the vast majority of schools. While Title IX is a very short statute, Supreme Court decisions and guidance from the U.S. Department of Education had given it a broad scope covering sexual harassment and sexual violence. 9 things to know about Title IX. 1. Title IX is a civil right. Title IX is a civil right that prohibits sex discrimination in education. 2. Title IX applies to all students regardless of gender identity. 3. Schools may not retaliate against someone filing a complaint and must keep complaints safe from other retaliatory harassment. 4. Schools should ensure that no student has to share campus space, such as dorms, classes, and workplaces, with their abuser. 5. Schools can issue no contact directives to prevent accused students from approaching or interacting with you. 6. Schools must be proactive in assuring that your campus is free from sex discrimination. 7. Schools cannot discourage you from continuing your education. Number 8. All schools receiving federal funding, including public K through 12 schools and the majority of colleges, are subject to Title IX. Number 9. Schools must have an established procedure for handling complaints of sexual discrimination, harassment, and violence. Both Title VII of the Civil Rights Act of 1964 and Title IX of the Education Amendments of 1972 provide protection against sex discrimination in the context of tenure. So what is the difference between Title VII and Title IX? Title VII is a federal law that prohibits discrimination in employment on the basis of sex, as well as race, color, national origin, and religion. Title IX is a federal law that prohibits sex discrimination in education, covering all staff and students in any educational institution or program that receives federal funds. Title VII and Title IX are similar, yet different from each other. As seen in the circuit split, courts have ruled Title VII preempts Title IX. Courts have decided that Title VII guides Title IX claims because it provides case law dictating the prohibition of sex discrimination. Unlike Title IX, which was enacted to prevent federal funding of discriminatory actions pursuant to Congress's spending power, Title VII was enacted with a compensatory scheme in mind. Individuals employed by educational institutions are covered by the terms of Title IX, and many claims have been filed under Title VII, but other times Title IX may be used. Title VII contains an express cause of action, provides for compensatory damages. Plaintiffs under Title IX need to exhaust administrative remedies or receive a right to sue letter from an administrative agency. Title IX damages vary from Title VII's. Title IX has no damages cap. Federal agencies may withdraw their federal funding under Title IX, but this is not the case under Title VII. Title IX was enacted under the spending clause powers. Federal funds may be revoked if there is a violation of Title IX. Does Title IX apply to same-sex harassment? Title IX protects all students from sex-based harassment, regardless of the sex of the parties, including when they are members of the same sex. How do these influence schools and students? Title IX complaints over schools mishandling sexual assault cases over the years. It's from 2009 to 2016. You have complaints against K-12 schools and complaints against colleges. Here are a few schools and universities that have had Title IX suits over the last few years. These are just a few of the major universities: Penn State, UConn, Baylor, University of Colorado, Arizona, Stanford, Princeton, Kansas, Yale. The list was too vast to put all of them on one slide, so these are just several examples. Hazing, bullying, and cyberbullying. Other school activities: pregnant and parenting student athletes, LGBTQ students, retaliation against reporters of Title IX violations. Title VII in education. In 2016, women earned about 80% of men. Within higher education, this gender gap persists in salary, hiring, promotions, and other aspects of academic employment. Professors can seemingly attempt to remedy this under Title VII of the Civil Rights Act or Title IX of the Education Amendments, both of which prohibit sex discrimination in higher education. Here are a few court cases. Doe versus Mercy Catholic Medical Center. Doe alleged that the director of Mercy's residency program, Dr. James Rowe, sexually harassed her and retaliated against her because she complained about his behavior, which resulted in her dismissal. Doe sued Mercy in the district court under Title IX for retaliation, quid pro quo, harassment, and hostile environment. She conceded she never filed a charge under Title VII of the Civil Rights Act of 1964. The district court held that Title IX does not apply to Mercy because it is not an educational program or activity. Even if Title IX did apply, the court did not believe it could use Title IX to circumvent Title VII's administrative requirements. On appeal, the Third Circuit examined whether Title IX applies to Mercy and whether Doe's private causes of action are cognizable under Title IX. The court ultimately held that Doe's medical residency program at the Mercy's Catholic Medical Center Hospital, which accepted federal funding through Medicare and was affiliated with Drexel University Medical Center, qualified as an educational program or activity under Title IX. Additionally, Doe's concurrent employment status fell under Title VII, did not preclude her from bringing private cause of action under Title IX. The Third Circuit's holdings align with the First and Fourth Circuit's decision that Title VII does not preempt Title IX, and these claims may be considered independently.